SJC-13748, Edward Pierce, petitioner.
Okay. Attorney Murray, whenever you're ready.
Good morning. Mary Murray for the respondent, Victor Correa. Public safety, the public interest, the orderly and cohesive development of the law, the correctness and ensuring the correctness of the ruling below, preserving the limits on the habeas that it is not an unreviewable substitute for appeal, and this court's superintendence over the lower courts, all are best served by appellate review of orders discharging SDPs, sexually dangerous persons, from custody, regardless of whatever title is given to the procedural mechanism below. The ancient principle embodied in the Wyeth case, although as the appeals court said in its own published opinion earlier in this proceeding, this case, which has been the question of some debate, that ancient principle, to the extent it continues to exist, seriously undermines all of those important interests. It serves no legitimate interest in modern society and encourages the manipulative use of the petition for writ of habeas corpus to thwart the Commonwealth's right to challenge the legal correctness of orders. It should now be formally overruled. As this court said just 11 months ago in Johnson versus Citino, you invite challenges to antiquated laws that conflict with modern societal norms, and you'll depart from precedent when doing so, and the values in doing so outweigh the principles of stare decisis, and that is exactly what is the situation here. The Commonwealth's appeal here is consistent with, or the respondent's appeal, the lower court referred to the respondent as the Commonwealth throughout, is consistent with ordered liberty. And that's the phrase that this court used in Hill in 1996 when it affirmed that the Commonwealth could appeal any—
What was the rationale for the Wyeth rule affirmed in 1989 in Averitt, suggesting or holding, I think, that an allowance of a writ of habeas corpus is not appealable? What was the rationale for that?
The rationale, the original rationale in Wyeth, I think, is lost to the mist of time.
Okay,
what we
you
do
don't know. What about Averitt?
Well,
it's not lost to the, it's not lost. It's that the purpose of the writ was to release someone quickly who's wrongfully held. So we don't want to have it a protracted appeal. Whether it makes sense in a modern appellate environment is a whole different question. But there's the logic of it is not lost in the mist of time.
It was this court saying it would not review an order of a single justice of this court, which is quite different than what we have here. However, in Averitt, to get back to Justice Wendland's—
Hold on, can you answer the question? The purpose of not allowing an appeal, we know what it was. It goes back to Chief Justice Shaw and all this language about immediate release. Whether it makes any sense anymore is different. We know what the thought behind it, don't we? You're jumbling 3 or 4 different concepts at once. Why don't you just focus one at a time?
Yes, that does seem to be the reasoning why the court determined you don't want to continue a wrongful incarceration or confinement. That's, of course, one of the competing interests here. That is, of course, one of the interests. However, ensuring the legal correctness of the orders releasing a sexually dangerous person, a person who's been found likely to reoffend sexually, is also an important public safety interest. And this court has recognized balancing that interest when it allows appeals by the Commonwealth in sexually dangerous person cases, which also involve confinement. And
Or you're asking for overruling Wyeth in the context of SDPs?
overruling Wyeth in general, and even—
So articulate for me your rationale for overruling Wyeth in general.
in general, because it is inconsistent with modern appellate practice and encourages the manipulative use of petition for writ of habeas corpus, which
Didn't
was
it
what
do
happened
so
here.
in Wyeth? Why has that changed? I guess you're arguing, citing Citino, that there's been some change, but it seems like that second rationale would have existed in the 1800s just as much as it exists in 2025. That it encourages the use of the writ of habeas corpus in order to evade appellate review.
It could have.
Okay.
However,
So what are the changes in the appellate procedure?
a statute which permits appeal from any order of the appeals court, of the Superior Court. I want to go back to one point because
So I thought Wyeth, though, was grounded in the constitutional principle about the need for the writ to be freely available, speedily available. How could the legislature enactment of a statute trump that constitutional principle? I'm not suggesting it doesn't. I just truly want to know.
the constitutional principle does not deprive appellate review. For example, in federal cases, under the federal habeas statute, the government can appeal. And courts,
But let's stick with the Commonwealth's Constitution.
so ensuring that the decision is correct does not infringe or violate any due process principle. Because the court can always, while the decision is pending, release somebody, which is what happened here. But on the other hand, the court can also permit a stay, which is what happens quite often when the Commonwealth appeals in an SDP case. You can measure all the factors and permit a stay. But I want to go back to an earlier point, which is why is
This point, I think we'd like to sort of figure out before you leave it. So the end of the appeals court decision talks about 211.3. If we didn't allow review of a habeas, could you still bring a 211.3? Could the Commonwealth still bring a 211.3? I don't know exactly what they were saying in the last part of it.
well, even if this court doesn't overrule Wyeth, getting to your point, the Commonwealth has been permitted in Pires, for example, to appeal whether habeas is an appropriate avenue of relief. And that was brought in Pires by means of a 211.3 petition. And the court decided it. I believe a single justice reserved and reported it, and this court issued a full decision and said, in this instance, that was a bail revocation case, 211.3 is not an habeas is not an available remedy, and returned the case to the lower court to dismiss the habeas petition. So it cannot be used as
that be the right outcome? Instead of overruling Wyeth, as you propose for all cases, SDP or not, why not just take the Pyrrhus route and say, whether habeas is at all available is something that can be appealed, but the allowance of habeas, if it's available, cannot.
And that is another alternative route to reversing the judgment here below, because habeas is not an.
Why would that not be the better?
It is what we urged the appeals court. Of course, we could not ask them to overrule Wyeth because we couldn't. We can't ask them.
But
to
you're
overrule
here
your
now.
orders.
I guess I'm wondering what you're saying. Pick your poison, dear justices, and I'm wondering. I'm giving you the opportunity to articulate an argument for one or the other.
We've argued for both. However, the one that is that doesn't require overruling Wyeth is certainly proceeding that the Commonwealth can challenge whether habeas is an available mechanism. I would point out that Wyeth has not always been followed. In Newton, this court entertained the Commonwealth's appeal, ironically an SDP case itself, of use of a habeas. And in other cases, in Bishop, that you said, or this court said, we weren't all here in 1898, although it might feel like it, it's doubtful if exceptions will lie, but then reviewed the merits. In Chambers in 1915, the same thing. In Harris in 1941, the same thing. And then in Needle and Stearns in the 60s, allowed the petitioners to appeal if they had been denied habeas. So the court, it has not been a straight shot. We never entertain appeals. And even in Averitt, the court looked at whether habeas was an available remedy and then proceeded to decide the matter. So to be sure, the Commonwealth or the respondent here at a minimum has the ability to challenge whether habeas is an available mechanism. And turning to that point, it clearly is not. Mr. Pierce here had not one but two opportunities to put his...
Going back to those cases that you cited, you're familiar with them, I'm not yet. Are all of those cases where this court reached the merits of the habeas as opposed to whether habeas was available or not?
Well, in Bishop, the court said, it's doubtful if exceptions will lie, but assuming without deciding the case is properly before us, they decided the issue and looked at the merits of the grant of habeas. And in Chambers, very similarly, the court said no appeal lies, but then considered the correctness of the ruling. So in essence, did entertain it. And in Harris, again, reviewed the correctness of the ruling and then said no appeal lies. And then in Needle and Stearns, which were the petitioner's appeals, looked at the issues. Now, turning to Mr. Pierce, he had...
So let's turn to Mr. Pierce for a second. I think the thing that's concerning is Mr. Pierce, there weren't two qualified examiners, right? And after Johnston, it's a no-no to keep someone committed without, in that context. So we have somebody at the treatment center without following the Johnston protocol. What remedy does he have besides habeas? And I don't want you to talk about your own internal remedy, but he shouldn't have been there without a qualified examiner.
Well,
So that's the troubling part of this case. So how does he correct that?
first, he forfeited his right to appeal. And it's important to understand it because he was being held on new criminal charges also when he was brought back to Massachusetts, and he elected not to pursue the striking of his notice of appeal. So he fled, forfeited direct appeal. Then when he came back, he tried to notice a late appeal, and he forfeited it. But what's important to understand is the timing of all of this with Mr. Pierce.
I'm just trying to get, if we don't find habeas is appropriate, what is the proper vehicle for him to have challenged that? Because he clearly shouldn't be in the treatment center based on the original charges, because both qualified examiners said he doesn't meet the standard. And Johnson says you don't go in. So that brings us sort of to that context like the appeals court case where the appeals court sort of says, well, in our past we said this habeas doesn't apply, but then we double talked a little bit. So I'm just trying to figure out what should he have done in that context?
His remedy was, if he chose to challenge that, an issue he had flagged, by the way, in summary judgment.
I know I know he fled, but Johnson's decided well after he fled. Now he knows he shouldn't be in the treatment center. And having someone in the treatment center is no joke. We like to have the procedures complied with, right?
Well, first of all, his commitment was constitutionally firm because the due process requirement of expert opinion was met. There was statute, it was voidable but not void.
That's true, but
I think the question is, I'm sorry, is there any mechanism by which a collateral challenge can be made on the original commitment order?
Not in this instance because of his own choice.
Generally, we're talking about generally, the equivalent of a Rule 30 motion. Is there anything like that available?
There are motions for new trials brought quite often.
Using Rule 30?
Well, it's a criminal rule, so it doesn't directly apply, but motions for new trial, in fact, McIntyre, which interpreted Johnstone to be a statutory construction, was a motion for new trial. So he could have brought a motion for new trial. He could have done a lot of things, but it's important to recognize that Mr. Pierce used the existence of the SDP commitment at the time he was sentenced. So Johnstone was decided on June 25th, 2008 by the appeals court, where they said, where the appeals court addressed it. Of course, this court then decides it. About 6 weeks later, on August 4th, he's convicted on the two sex crimes, the rape of a child and the indecent A and B, and convicted on the other charges against threats and intimidations through a separate bench trial. And when he is being sentenced, his attorney, by the way, the same attorney who was his attorney in the underlying commitment proceedings, Mark Gillis, says to the court, "Judge, we urge you to sentence him to a lower sentence, because he won't be out again until he's determined to be safe through the SDP process." So he already knew about the QE issue because he raised it pre-trial in 2001. Then Johnstone is decided, so it's decided by the appeals court 6 weeks earlier, and then he used it. He could have done that, but he said he wanted to stay at the treatment center.
I just think we're more, the equities here we're less interested in than the procedures, the proper procedures to sort out here. I mean, I understand he's a repeat offender. We get all that. We're just trying to figure out what's the right procedural vehicles in all these stages.
He could have brought a motion for a new trial in the underlying case, and that could have been entertained. However, if it had been invalidated, he would have then been open to be committed, to be petitioned on again at the end of the criminal sentence, which expired in 2022. And Mr.
Okay, so is it your position that the reason why habeas petition should not be available is because he had an adequate alternate remedy in the form of a, I guess it would be Rule 60 motion?
He had an adequate alternative remedy. To be clear, the civil rules don't technically apply.
Okay,
but
so
they are
it
followed
would-
as near as possible.
It would just be a motion for new trial.
Motion for new trial, which
Do you continue to maintain the position that a petition under Section 9 of the statute is an adequate alternate remedy? Because if you do, I have some questions about that.
yes, and because what he would be looking for is securing his release.
You're right, but that's a different question. He wouldn't be able to relitigate the correctness of the original commitment order, correct, in his Section 9. So in that sense, it's not really a substitute for the motion for new trial.
He could have brought a motion for new trial.
Okay.
But he did not, ever.
Okay, so, and the Section 9 would not do anything in terms of, would not be a collateral challenge to the original commitment order.
No, because the question is whether he
Right.
remained sexually dangerous at the time of the Section 9 trial.
And there is a distinction between the Section 9 petition in that the original commitment placed the burden of proof on the Commonwealth, whereas the Section 9 places the burden on the defendant, no, it does
No,
not?
in all SDP proceedings, whether the trial of the initial commitment case or the trial of the Section 9, the burden of proof beyond a reasonable doubt is on the Commonwealth, and it stays on the Commonwealth throughout the proceeding. So at no time does the petitioner, would Mr. Pierce, either at the initial commitment case or at a Section 9, have any burden of proof. And he did say he had 5 petitions for discharge. He withdrew them all, and in 2017 said in an affidavit, which is in our record here, that Mr. Pierce said in his own affidavit that if I go forward, I'm not likely to be successful, and that's why he was withdrawing. So the Commonwealth asked the court, the respondent, again referred to below as the Commonwealth, asked the court to reverse the order of the Superior Court and remand Mr. Pierce to custody.
Okay, thank you. Okay, Attorney Keneally.
And please call your honors, Joseph Keneally for Mr. Pierce. I'd like to start by addressing something that came towards the end of the argument in terms of the different collateral avenues to address these situations. And the problem is, this is one of the things that was considered when the determination was made to file a habeas petition in the first place, because there really is no set rule for how one goes about
What about a motion for a new trial?
a new trial motion. I mean,
Is that like an unknown thing in SDB practice?
Well, to the extent that Rule 30 doesn't apply. You can't file a Rule 30 motion because it's not a criminal case.
Attorney
You
Murray
agreed.
just said that
Sorry.
it's done on a pretty, I mean, that's a known practice. Are you saying it's not?
It is done, but I would submit it's murky because there's no rule attaching to how this one goes about a new trial motion in an SDP case.
Did you try it?
A motion for a new trial, that's Rule.
I'm saying, did Mr. Pierce try that? Did he?
No, he did not. We filed the habeas petition instead.
But why doesn't that make sense? Because it's not an apples to apples analog, but if you are a defendant and you happen to be subject to some civil immigration issue, a detainer or removal, what does the person do? They go back to the original criminal case and they file a Rule 30 motion and say, I need to get a new trial. So why wouldn't it be the same if you've got this SDP case that you've got that's civil, and you say, hey, there's been a problem here where there wasn't the QEs that we needed under Johnstone, so I'm going to go back to the criminal case and file a Rule 30 motion.
Because the judgment is not a criminal judgment. The judgment is.
Not a Rule 30, just a motion for a new
Oh,
trial.
just a general motion?
Yeah.
I suppose that could be a way to approach it. I don't think that necessarily excludes filing a habeas petition instead, and I don't think the law requires necessarily.
Doesn't habeas say it applies when there's no other remedy?
I don't believe so, Your Honor.
No other adequate remedy?
I don't believe so.
That isn't certainly the case law says it.
My understanding was that a Rule 30, that a habeas petition was available when the individual was entitled to immediate release due to an error of law. Generally, when you're asking for a motion for a new trial, you're asking for just that, a new trial. The issue is whether or not the trial was correct or not. This issue in a habeas petition is whether the individual is eligible for release from confinement, whether civil or criminal.
Well, then let's turn to actually what happens here then. Because part of all of this is because your client absconds, right? And leaves, right?
Well, I mean,
No, because it's part of this, because you don't really wrestle with this in your brief. But the issue with the notice of appeal that was struck,
yes.
right? That wasn't appealed for 3 years, right?
It was not.
So, but you don't grapple with that. So how do we assess your claim of habeas and saying that you're entitled to this immediate relief when there was an avenue there that wasn't perfected, and even when that was struck, that wasn't appealed?
I guess that goes to the larger question, Your Honor, about can process foreclose looking at something where an obvious injustice took place? We have a situation here where we know, and I don't think that there's any question that this commitment was invalid. There were not sufficient qualified examiners. The case never should have gone to trial. Okay, so in those circumstances, the government's position is like, well, he absconded and he tried to get his petition, his appeal reinstated. The government fought it and we happened to win and he didn't appeal, so now he blew it. So now we just have to pretend that Johnstone doesn't apply, and that even though there are no qualified examiners, and even though this case should have never gone to trial, we're ignoring all of that because he didn't go through the proper procedures.
Well, isn't that why our whole system is based on procedural rules? We all agree to go by these rules. And
It
so
certainly
you're
is.
saying, let's just forget them and focus on what my client wants.
Well, there are circumstances where process is not paramount to this court's review. And in Commonwealth versus Randolph, this court explained exactly when those circumstances are. This court set out the different exceptions to waiver, and they also characterized the substantial risk of a miscarriage of justice standard, where they said, this is not an exception to waiver. This is a default standard that we apply in every circumstance where a claim is waived. And the reason why they did that was because back in the olden days, to 150, 160 years ago, it was just that. If you waive it, it's tough luck. Guilty, not guilty, in jail, not in jail. If you waive it, you're done. You blew it. And that's what the government's argument is here.
Right. I think that they have maybe modified their argument a bit, because in their brief, they definitely argued that the forfeiture of a direct appeal was the issue. And let's assume that's not the issue. Let's assume that the availability of a motion for new trial to collaterally challenge the original commitment order is still available, has always been available to your client. Then that seems to me perhaps the real issue about whether habeas was the appropriate route instead.
Well, like I said, I mean, the new trial motion does speak to whether or not a new trial should be had. In this case, where our position is not that a new trial should be had, but that the first trial never should have happened in the first place, and that Mr. Pierce is being illegally held as a result of that.
What about a motion to vacate the commitment order?
I frankly haven't considered that, Your Honor, but Case Bates versus Commonwealth, this court said, I don't have the site in front of me, I was looking for it, basically said that just simply because a case is not available, habeas was an inappropriate vehicle. It does not foreclose those opportunities.
No, but I'm just reading from the appeals court decision, which is quoting a bunch of our cases. Habeas corpus cannot take the place of a writ of error in a case which was within the jurisdiction of the court and where the only question raised is the correctness of the rulings of the court. Habeas corpus must be based on grounds distinct from the issues at the indictment, trial, conviction, or sentencing stage. It goes out of a criminal case, but I assume it seems like there's a lot of case law that says that.
There is, Your Honor, and there's a lot of case law that says that if you don't bring something on direct appeal, you can't bring it up in a new trial motion. And the Commonwealth versus Emerald, Commonwealth versus Lefebvre say that. And they say if you don't bring it up in your first new trial motion, you can't bring it up in your second. But it happens all the time.
In criminal.
Yes,
Okay.
in criminal cases.
This
However,
is not a criminal procedure.
however,
This is not a criminal procedure.
no, it is not. But the waiver standard of the criminal case specifically applies to STP cases. That's the RB petitioner. In RB, they said,
Well, even Randolph, we always have the backup plan. There can't be a substantial risk of a miscarriage of justice in criminal cases. So there's no pure waiver. And we've applied that reasoning to SDP cases. So waiver is not going to kill you in this context.
well, and that's what I'm saying. A waiver shouldn't kill you in the habeas context either. There's no functional.
It's not waiver, it's saying you have another remedy.
Right.
You have another remedy, which is a motion for a new trial.
Well, if that remedy, if the sticking point is that Mr. Pierce should have filed a motion for a new trial, I would imagine that remedy would still be available. And if in fact, but my point here is that the substantial risk of a miscarriage of justice standard should apply to habeas cases as well. Not because the language saying you can't bring it up on habeas if you didn't raise on direct appeal is the same rule that applies to Rule 30 cases. And since those cases, those claims not brought up on direct appeal are deemed waived, we apply the substantial risk standard. And if you apply the substantial risk standard in this case, Mr. Pierce remains free from custody because we know this trial shouldn't have happened. There was not sufficient evidence to bring the case to trial. And as a result of that, case Commonwealth versus Watkins, this court said that if the evidence is insufficient to support a conviction in that case, that is by nature a substantial risk of a miscarriage of justice.
But going back a couple of dominoes, which I don't think I hear you saying, you're saying you want us to announce a new rule.
I don't think it's a new rule, Your Honor. I think that waiver applies to or the substantial risk standard applies to STP cases.
See, I think you're confusing waiver with when habeas corpus is available. It's not available when you have another mechanism to bring your claim.
Well, if in fact
So it's not that your client waived the lack of compliance with Johnstone. It's that habeas is not one of the pick your item, places where your client can get any relief because he had alternative remedies.
Well, if that's in fact the situation where Mr. Pierce should have just filed a new trial motion rather than file the habeas petition, and if that's still available to him to do that, that is inconsistent, I would suggest, with the Commonwealth's position, which is essentially that he just needs to accept
They may be wrong.
The claim.
They may be wrong too on that.
That would be my suggestion, Your Honor. And I think that ultimately, and the whole notion as to whether to file a Section 9 petition, that's not addressing the error, it's ignoring it, essentially. It's basically saying, we're just going to pretend that he was legitimately committed and make him go through the process. That's not really collateral review of this particular case.
No, that's the Rule 30, or that's the motion for a new trial, and with it, a motion to vacate the
Commitment order.
Commitment order.
Yeah, given the obvious error, and I don't think that the government even really challenges the notion that this was a Johnstone error and that this trial never should have happened. I don't think that they challenged that in their brief. But in the event that
Is Johnston issued during the time your client is on the run, or is Johnson issued after your client?
Johnstone was decided in 2009, Mr. Pierce absconded in 2002 and was returned to custody in 2005.
So in 2009, when Johnson issues, his lawyer should say, oh, motion for a new trial, motion to vacate, because Johnson is giving new guidance to the courts. And my original commitment was clearly, I'm not saying whoever was doing this, but there's an obvious vehicle, and it actually is not impacted by the fact that your client absconded.
It is not. And Your Honor, I mean, to that point, I would suggest the Department of Corrections, which was holding Mr. Pierce, could have realized that he was being held pursuant to an invalid judgment, a trial that shouldn't have happened. They could have filed a motion for declaratory judgment, had his SDP order vacated, had him remanded to the DOC where he was serving a criminal sentence, and then when he was about to be released, could have gone through the SDP process. The government had 13 years to do that. Between 2009, when Johnstone was decided, and 2022, when his sentence ended, they could have done that. They did not do that. They just...
So he's being held under the first set of convictions, there was a second set of
Yes.
convictions, right?
When he first went to trial, in lieu of qualified examiners, the Commonwealth brought evidence of uncharged conduct, victims of his offending. He was determined to be SDP. He absconded. And then those victims to the uncharged conduct who testified, they were the ones who were, those were the basis for the indictments. So he gets returned, shipped off to the treatment center. The indictments come in. He gets sentenced. He's doing the sentence at the same time as the commitment. And the sentence lapse, he gets a certificate of release from the DOC. And now the only thing holding him is this Johnstone error violation. So hence the...
Back to the Chief's question, they didn't use the second set of convictions.
There weren't, it sounds like there was only one set of convictions, it was the same conduct.
Well, yes. I mean, the SDP trial, the SDP petition was based on one conviction.
The earlier ones.
The second set of convictions were never factored into any of this because there was no subsequent SDP petition that was filed.
Right.
So, you know, just to wrap up here, I would suggest there's no reason to overturn 165 years of precedent that's consistent with the Constitution, that's consistent with Chapter 248. You don't need to overturn this law. The government seems to have the position that overturning Wyeth is like shoveling dirt on a casket or something like that. But
I just want to go back to if he's being held for that same conduct and he is now been found to still be sexually dangerous by now qualified examiners, what are we talking about?
Well, he cannot be.
He's on the street.
He can't be petitioned against because once you've served,
he waived his chance to challenge this based on the subsequent criminal offense.
Well,
he hasn't brought a Section 9 to get himself out.
No, and that's the most important difference between this and the McIntyre case, where in McIntyre he filed 3, and this court said, look, yeah, the first one without QEs is bad, but he's had 3 more, and the most recent judgment was the one that holds. So I know
Can you just clarify for me? Is he in custody?
he's not in custody. He's been out. He's been out for 2 years now.
Okay. I just want.
He's at the treatment center.
He's not at the treatment center. He was released on habeas
He's right. He's on the street.
for 2 years. The past 2 years, he was released in September 2023. I know I'm way over. I would just finally suggest that if you look at the briefs, there's really no reason to overturn 150 years of precedent here. It's consistent with the Constitution, consistent with the Chapter 248, and consistent with 150 years of case law. So I appreciate your time. Thank you, Your Honors.